Hello and welcome retailers and manufacturers to TP Ignite 2022. My name is Ben Stimson, Senior Director with TMG Media, and we're excited to bring together the industry's top experts to share their insight and knowledge on current market legislation and regulatory issues. Today's educational session on tobacco legislation and regulations is being presented by Tom Briant. Tom serves as the Executive Director and Legal Counsel for NATO, the National Association of Tobacco Outlets. Tom has worked on tobacco issues at a retail, wholesale, and manufacturer level for 32 years and brings a wealth of knowledge and expertise on legislative and FDA tobacco issues. Tom's session today will provide an in-depth update on the latest FDA tobacco regulations, pre-market tobacco application reviews, state legislative agendas, the proposed ban on the sale of all flavored products, and synthetic nicotine. Please be sure to post any questions or comments in the comment section, as we will be having a live question and answer at the end of Tom's presentation today. Tom, I'd like to welcome you today. How are you?
Doing well, Ben. Thank you for having me today.
No problem. And thank you again. You did a tremendous job last year. This is our second year doing the TP Ignite online educational sessions, and we're glad to have you back again this year. I'm sure 2021 has been a hugely busy year for you, and looking forward to 2022. I'm sure it's going to be another busy year for you guys, right?
Yes, it will. 2021 was with a lot of success both on the state and federal legislative levels, but we're looking for more challenges in 2022.
Wonderful. Well, Tom, without further ado, I know we're on a time limit here, so I'm going to pass over to yourself for your presentation, and we'll touch base here in just a few minutes.
All right, we'll be ready for our presentation now, Antoine.
Thanks very much.
Thank you again, Ben, and welcome to the TPE Ignite educational session on tobacco legislative and regulatory updates. I want to extend NATO's appreciation to the sponsors of today's educational session, which includes Platinum sponsor, Altria Group Distribution Company, Bronze sponsors, ITG Brands and National Tobacco Company, and this is all conducted in partnership with Cratank International and the 2022 TPE Trade Show. For today's session, we'll cover 7 different topics. First, legislation in Congress that would have significantly increased federal cigarette and tobacco taxes and imposed a new tax on electronic cigarettes and nicotine vapor products. Second, the upcoming FDA regulation to ban menthol in cigarettes and prohibiting flavors in all cigars. Third, an update on the status of the FDA graphic cigarette health warning statements. Fourth, a look at where the FDA stands with reviewing pre-market tobacco applications, or PMTAs. Next, a look at the issue of 2 different kinds of nicotine and what Congress is doing to extend the FDA's authority to directly regulate synthetic nicotine. Then, we will briefly review the corrective statements litigation that has been ongoing for some 22 years and should be coming to a conclusion this summer, and how that could impact tobacco retailers. And finally, I'll look at state legislative issues during 2021, as well as local tobacco ordinance activity, and then what to expect in 2022 on a state level. So let's turn first to the legislation that would have raised federal cigarette and tobacco tax rates. During the 2021 congressional session, Congress considered a budget reconciliation bill that included significant increases in the federal cigarette and tobacco tax rates. However, the increases were removed from the bill, and the bill is yet to be considered by the full U.S. Senate. But even though the tax increases are no longer in the bill, it is important to understand just how significant the rate increases would have been, and because of an industry-wide effort, those increases were deleted from the legislation. This slide shows both the current and what the proposed federal tax rates were under the federal legislation for cigarettes, small cigars, large cigars, and moist snuff. The tax on cigarettes and small cigars would have increased 100%, or doubled, to $2.02 a pack. The tax on large cigars would have changed in 2 respects. One change was to a dollar amount tax of $49.56 per pound. the second change would have implemented a minimum tax of at least 10 cents per cigar. Now, the tax on moist snuff would have seen a 1,700% increase, almost unheard of, to $26.84 per pound. Chewing tobacco would have seen a 2,000% increase in the tax rate, up to $10.74 per pound. And roll your own cigarette tobacco followed the same doubling like the cigarette tax rate. Finally, a tax was then subsequently proposed on modern oral and e-cigarettes to $1.15 per pod or $4.45 per 20 pack of pouches or lozenges. The takeaway from this congressional attempt to raise tobacco taxes is that it could happen again. Federal tax rates were last raised in 2009. That's some 13 years ago. So it is important to remain watchful for future congressional moves to raise tobacco tax rates, even though the legislation has not passed Congress as of yet. The need to remain vigilant for any future federal tax increases can be seen by the potential impact of such tax rates. As a part of the effort to oppose these tax increases at the federal level, NATO commissioned an economic study to estimate the impact on sales, jobs, and tax revenue collections. The study found that on a national level, the economic impacts would have resulted in $801 million in lost cigarette and tobacco product sales. That's at the retail level. That is almost $1 billion in reduced sales for retailers. Then, it estimated 14,000 plus jobs would have been lost in the retail and allied segments. And finally, the states would have lost $1.26 billion in state cigarette and tobacco tax revenue and sales tax revenue as well. Now, NATO used the study to educate all state lawmakers and all members of Congress so they would understand what would happen economically if the increases were actually enacted. As I indicated, the congressional legislation initially included the cigarette and tobacco tax increases, but all of those were removed from the bill. Then, Congress put in a new modern oral and vapor tax into the Build Back Better version of the legislation. But the U.S. Senate committee deleted those new taxes from the bill as well. So, currently, as I stated, the legislation, which is still pending in Congress, specifically the U.S. Senate, has no tobacco or vapor tax increases in the legislation. Now we move on to FDA rules and regulations. On April 29th of 2021, last year, the FDA announced that the agency would propose by April of 2022, about 3 months from now, what are known as product standards, which would ban the use of menthol in cigarettes and ban flavors in cigars. It is important to understand that the FDA has the authority to adopt product standards without further congressional action. For definitional purposes, a product standard is the power that Congress gave to the FDA to reduce or eliminate an ingredient in a tobacco product or a constituent in tobacco smoke. Let me state that again. It's a power to reduce or eliminate an ingredient in a tobacco product or constituent in tobacco smoke. This is a very significant power for the FDA because it can result in products literally being removed from the market if the manufacturers cannot make the product any longer without that ingredient or that constituent. Now, when a regulation will be proposed, as the FDA plans to do so with menthol in cigarettes and flavors in cigars, every federal agency must follow a 9-step process. These steps include drafting a new regulation, having the proposed regulation reviewed by the White House Office of Management and Budget, requesting the public to comment on the proposed regulation, reading all of the public comments submitted, making amendments or changes to the proposed regulation, going back to the Office of Management and Budget for review and final approval, and then publishing the final regulation with an effective date. The time it takes a federal agency to go through each of those steps before a new regulation can go into effect is generally a couple of years. What does this mean? It means that the prohibition of menthol in cigarettes and flavored cigars will not occur in the near term, but could take a couple of years. Moreover, if litigation were then to be brought after the regulation was finalized, that could delay the implementation of the regulation even further. Moving on to the FDA graphic cigarette health warnings. In the 2009 law, known as the Family Smoking Prevention and Tobacco Control Act, Congress authorized the FDA to require new graphic cigarette health warnings to be printed on cigarette packages and on cigarette advertisements. Now, these new warnings are meant to replace the current Surgeon General warnings that are included on cigarette packs and cigarette ads. This is not the first time that the FDA has proposed new health warnings. The agency proposed 9 new graphic picture warnings in 2011, some 11 years ago. But cigarette manufacturers sued to block the warnings, and a federal appeals court struck those warnings down. The agency then set about compiling a second set of warnings and finalized this second regulation for the new cigarette health warnings in March of 2020. However, 1 month later, in April, and then 2 months in May of 2020, 2 lawsuits were filed against the FDA seeking to overturn the new graphic cigarette health warnings. R.J. Reynolds Tobacco Company, Santa Fe Natural Tobacco, and ITG Brands filed the first lawsuit in April of 2020, and then Philip Morris USA filed a separate lawsuit in May of 2020. Based on court orders, the implementation date for the new warnings to go into effect is now January 9th of 2023, literally 1 year almost to the date, unless the court would extend that effective date. The court has extended the effective date a number of times because the actual merits of the case have not been decided yet. In other words, a final decision on whether the warnings will be overturned or not has not been made by the courts. So in the meantime, they keep extending the effective date of the regulation. This slide shows the 11 different graphic pictures and corresponding text warnings that the FDA has now proposed to go into effect. These are the second set of warnings developed by the FDA, and these are the warnings that are subject to those 2 lawsuits by the manufacturers. These pictures are FDA mock-ups showing the new graphic warnings on a pack of cigarettes and a cigarette ad. On a cigarette pack, the warnings need to cover the top 50% of both the front and rear panels of each cigarette package. For cigarette advertisements, the warnings need to cover at least 20% of the top part of a cigarette ad, like on the top of the magazine ad page that you see on the right-hand side of the screen. Now, remember this 20% space requirement when we get to the discussion of the corrective statements retail signage remedy I'm going to speak about shortly. As a part of the graphic cigarette health warnings, the FDA is requiring that a written cigarette health warning rotational plan be filed with the agency for review and approval. For cigarette advertisements that need to include these new graphic warnings, a cigarette warning rotational plan is a document that shows which of the 11 different cigarette health warnings will appear on ads during any given consecutive 3-month period. Remember, these warnings have to rotate every 3 months, and the plan would show which warning goes in which month and which quarter. Now, acknowledging that manufacturers will be required to print the graphic cigarette warnings on cigarette packages, any company that creates cigarette ads or causes cigarette ads to be created must also file a rotational plan. This would include retailers. And the kinds of retail-created cigarette ads would include posters, website ads, social media ads placed by a retailer email advertisements sent out to their customers, and newspaper ads created and printed for retailers. Now, what does cause cigarette advertisements to be created really mean? It means that a manufacturer or retailer that creates a cigarette ad in-house or retains another company to create cigarette ads for them must file a rotational plan with the FDA. For example, if a retailer hires an outside ad agency to create cigarette ads, the retailer needs to draft and file a rotational plan and then ensure that the health warnings are printed on the advertisements in the proper 3-month rotating sequence. Remember the court order that extended the effective date of these cigarette ads? That court order also extended the effective date for filing these rotational plans with the FDA. And the FDA's preferred filing date for these plans is now March 12th of 2022, about 2 months from now. That is when the FDA would like to see these plans filed with them for their review purposes, unless, again, the court extends that time period. Another FDA topic that is on a lot of people's minds are the status of the pre-market authorizations for applications for tobacco products. Federal law and FDA regulations require that before a tobacco product may be introduced into the U.S. market, the new product must undergo what is called pre-market review by the FDA and receive marketing authorization from the agency. This applies and would include cigars, pipe tobacco, electronic cigarettes, vapor products, hookah tobacco, and modern oral products such as lozenges or pouches that were on the market as of August 8th, 2016. That's the date that the FDA extended its authority to regulate those particular products: cigars, pipe tobacco, e-cigarettes, vapor, hookah, and modern oral. Now, if a product was already on the market as of February 15th of 2007, the product is what is called grandfathered and does not need a pre-market application, nor is FDA marketing authorization required. However, for every product that entered the market after February 15th of 2007, one of two pre-market applications was required to be filed. Either a substantial equivalency application, or for short, SE. That kind of application compares a new tobacco product to a similar one that is grandfathered or already has an SE approval order from the FDA. The second kind is the pre-market tobacco application, much more common, called a PMTA. And that's required for a new tobacco product that is not similar to a grandfathered product. And the application has to include comprehensive product information, clinical studies, and even samples of the product. Now, the FDA had a court-imposed deadline for all of these SE and PMTAs to be filed by manufacturers by September 9th of 2020. Once a manufacturer would have filed an SE or a PMTA, the FDA has to follow a four-step review process. First, the FDA conducts a very preliminary review of an application to see if everything is complete. Are all the required parts of the application present? If so, the agency initially accepts the application. Then, the agency files the application if all of the scientific studies, evidence, or other data required accompany the application. It's a more in-depth review, and then it's filed if all those parts of the application are present. The third step the FDA undertakes is a substantive review of the application. Now, by court order, those substantive reviews were supposed to be completed by the FDA by September 9th of 2021. However, the FDA didn't complete all of its reviews by that time, and I'll talk about that in a minute. The final step for the FDA is to issue an order, either authorizing or not authorizing the application. To authorize a PMTA, to allow that product to remain and be sold on the market, the FDA needs to determine that the product is appropriate for the protection of the public health. This is the standard that the Congress put in the federal law authorizing the FDA to review new tobacco products. Again, a product has to be appropriate for the protection of the public health. Regarding product pre-market tobacco applications, PMTAs, the agency received 15,020 PMTA applications by that September 9, 2020 filing deadline. Now, this includes applications for most categories of products, but the vast majority were for electronic cigarettes and vapor products. This chart shows the number of products covered by those 15,020 PMTA applications. So the PMTA applications covered 6,900,000 plus e-cigarette and vapor products, almost 7 million e-cigarette and vapor products, 304 cigarette products, a little over 2,000 cigar products, almost 700 hookah products, about 568 pipe tobacco products, 63 roll your own products, and 39 smokeless products. However, look at the third column in the chart. There are three acronyms there. RTA means the FDA refused to accept an application. Remember, that's the first step in the four-step process, acceptance. So the FDA refused to accept 5,773,202 products under PMTA applications. RTF means the agency refused to file the application. That's after taking a more hard look at the parts of the application something was missing. And EID stands for an environmental impact report deficiency, which means the application did not adequately address whether the product would significantly affect the quality of the human environment. So as I stated, the FDA has refused to accept and refused to file applications covering close to 6 million electronic cigarette and vapor products. What does that mean? It means those products that were under an RTA or RTF had to be removed from the market immediately and could no longer be sold. Now, the FDA has also issued what are called marketing denial orders, or MDOs, in response to PMTAs. A marketing denial order means the PMTA application was substantively reviewed and then denied, and the products which are the subject of a PMTA that is denied must be removed from the market immediately. As of the most recent FDA actions on their website taken through October 6th of 2021, 323 marketing denial orders, or MDOs, were issued to 260 different manufacturers that filed PMTAs for e-cigarettes and for nicotine vapor products. Those 320 MDOs covered 1,167,000 electronic cigarette products, which had to be removed from the market because they were under an MDO. However, an increasing number of manufacturers that received MDOs are now appealing those findings either directly with the FDA or contesting them through lawsuits filed against the FDA. And so far, several dozen manufacturers are contesting their MDOs. To date, the FDA has issued only one marketing authorization order, allowing R.J. Reynolds Vapor Company's Vuse Solo unit device and 2 Vuse replacement cartridges to continue to be sold in the marketplace because they were found to be appropriate for the protection of the public health. And those replacement cartridges were for tobacco-flavored nicotine. So no flavored electronic cigarette product has been approved as of this time. As I indicated, the FDA was under a court order to complete the review of all PMTA applications by September 9th of 2021. However, the FDA didn't finish its review process of all those 15,000 applications by that date. Since the agency didn't meet that court deadline, the FDA has exercised what is called agency enforcement discretion. That is the discretion of a federal agency to continue a review of an application process, even though the deadline for that review has passed. This means the FDA is continuing to review PMTA applications, and additional decisions, either marketing denial orders or marketing authorization orders, will be published in the near future. We have not heard if the FDA is going to finalize the applications that are pending or by what date. We'll just have to wait for the FDA to announce the results of its review and whether MDOs or marketing authorization orders are issued. Turning to the issue of synthetic nicotine, and this is a fairly new topic, some background on the FDA law is important so you understand where synthetic nicotine fits in the scheme of regulation. The Family Smoking Prevention and Tobacco Control Act, remember that's the federal law that authorized the FDA to regulate tobacco products, defines a tobacco product as any product made or derived from tobacco, including a component, part, or accessory of a tobacco product. So it has to be made or derived from tobacco, the actual tobacco leaf, in order to be a tobacco product under the FDA regulations. So if synthetic nicotine is not made or derived from tobacco, then technically synthetic nicotine may not be a tobacco product. However, the FDA has publicly taken the position that synthetic nicotine may still be a component or part of a tobacco product if it is used in a device, such as an electronic cigarette or a vaping device. Since the FDA can regulate components and parts, which are devices, then it's basically stating it can regulate whatever is put into those components or parts, or what is put into an electronic cigarette or a vaping device. This classification of synthetic nicotine as a component or part could subject synthetic nicotine to the FDA's regulations. And the agency has publicly stated that it'll make a determination on a case-by-case basis whether a synthetic nicotine product is regulated as a component or a part of a tobacco product. Now, a real challenge is the increasing difficulty in testing and differentiating tobacco-derived nicotine from synthetic nicotine. Why? The difficulty arises because nicotine itself has two what are called isomer forms, a R-nicotine isomer and a S-nicotine isomer. What is an isomer? An isomer is a compound that has the same chemical formula, but the atoms in the compound are arranged differently. Nicotine that is derived from tobacco has an isomer that is made up of 99% S-nicotine. Prior synthetic nicotine compounds were made up of about 50% R-nicotine and 50% S-nicotine, so it was more easily able to distinguish synthetic nicotine from tobacco-derived nicotine. But newer synthetic nicotine compounds can consist of more than 99% S-nicotine alone, making it very difficult to distinguish synthetic nicotine from tobacco-derived nicotine. According to the FDA, manufacturers of an increasing number of electronic cigarette products use or claim to use synthetic nicotine instead of a nicotine derived from tobacco. As a part of these claims, several manufacturers that were issued marketing denial orders by the FDA for their electronic cigarette products have made public statements that they are using or switching to synthetic nicotine to keep their products outside the scope of the FDA authority and to keep selling their products on the market. Now, separate and apart from these challenges relating to distinguishing synthetic nicotine from tobacco-derived nicotine, President Biden has nominated Robert Califf to be the new commissioner of the FDA. During a nomination hearing held on December 14th, just this past month, by the U.S. Senate Health, Education, Labor, and Pensions Committee, nominee Robert Califf stated that he would work to close the nicotine loophole, as he called, if appointed by the U.S. Senate to be the next commissioner of the FDA. Then, on that same day, a bill was introduced in Congress called the Clarifying Authority Over Nicotine Act of 2021, which would clarify that the FDA's regulatory authority over tobacco products includes products made with tobacco-derived nicotine and also synthetic nicotine. And if that bill were to become law, then it would be clear the FDA has full regulatory over products with synthetic nicotine. The next topic is an update on the corrective statements litigation. In 1999, some 23 years ago, the U.S. Department of Justice filed a lawsuit against the major cigarette manufacturers. A 2006 federal district court ruling in that case required the manufacturers to publish what are known as corrective statements on TV, in major newspapers, and in brochures attached to cigarette packages. These corrective statements were made to correct the statements made by manufacturers decades ago about the health impacts of cigarettes. Now, this same court order in 2006 also required each of the manufacturers to display a sign that would be 18 inches wide by 30 inches high on retail store counters, and those signs would contain copies of the corrective statements. However, a U.S. Circuit Court of Appeals overturned that retail signage requirement. Then, the Department of Justice, or DOJ, which had brought the lawsuit against the manufacturers, came back with a second retail signage proposal for stores that are under a promotional contract with the manufacturers. This second DOJ proposal requires Altria, Philip Morris USA, RJ Reynolds, and ITG brands to display on a rotating basis for at least 2 years 18 different point of sale signs with 18 different corrective statement messages in retail stores. And the signs must cover 25% of the area of point of cigarette displays for each of the manufacturers. So on a back bar behind a store counter, these signs on a rotating basis would cover 25% of the entire back bar displaying cigarettes for those three manufacturers over a 2-year period. Now remember, the FDA's graphic cigarette health warnings would need to cover the top 20% of a cigarette advertisement? When you combine the 20% for a graphic sign warning and the 25% for a corrective statement sign warning, that means 45% of the area of a cigarette ad would be covered by 2 different government messages. As I stated, the original 2006 court order had each manufacturer displaying 1 corrective sign. Now, the second remedy by the DOJ requires displaying these 18 signs with a different message for 2 years. Each of the manufacturers that are a party to this litigation, along with NATO, are opposing this new 18 sign requirement. From a retailer's point of view, the requirement is simply unfair and unconstitutional because retailers were never a part of this DOJ lawsuit. Moreover, retailers did not make the statements that the decades ago that need to be corrected. All of this is leading up to what is called an evidentiary hearing, which is like a trial, scheduled for this summer in June and July in Washington, D.C., to determine whether these 18 messages needed to be displayed in retail stores. This slide shows an example of one of the DOJ signs and how it would be affixed to a back bar cigarette display. The sign reads, "More people die every year from smoking than from murder, AIDS, suicide, drugs, car crashes, and alcohol combined." And there's 18 different messages similar to that would need to be displayed. Note the size of the sign. It covers 2 full racks or rows of cigarette packages plus 3 price channels below those cigarette packs. As you know, those price channels are important because they hold price information for customers or inventory tags for clerks to restock shelves and conduct an inventory. Now we're going to turn from federal to state tobacco legislation. This slide shows those states that had bills introduced and are acted upon in 2021, last year, that would increase cigarette and tobacco tax rates. The states in red had tax bills that were defeated, either by a committee vote, missing a committee deadline, or a floor vote in the state house or the state senate. The states in yellow, though, have bills pending if the legislature is still in session, or the bills are going to carry over to the 2022 state legislation if they were not acted upon in 2021. In other words, every state in yellow has a cigarette or tobacco tax increase bill that is going to be considered in 2022. Those bills are still alive. Maryland is shown in green and is the only state that had an increase in 2021. However, that cigarette and tobacco tax increase in Maryland was adopted in 2020, vetoed by the governor in 2020, and then the legislature came back in 2021 and overrode the governor's veto. So really that tax increase wasn't enacted in 2021. It was passed first in 2020, and then the veto was overridden in 2021. Otherwise, no other state passed a cigarette or tobacco tax increase this year, which was good news for retailers and the industry. But as I said, a lot of these same states are either going to carry over bills to this year's session or could reintroduce those bills for consideration again in 2022. So we need to remain vigilant because there's 25 states that had these bills last year that could also be considered for 2022. Similarly, this slide shows those states in red where vapor tax bills or e-cigarette tax bills were defeated, and those in yellow where final action was not taken and are being carried over to the 2022 session. Now, California, Indiana, and Maryland are shown in green because they did pass or enact a vapor tax or a vapor tax increase. Again, for those states in yellow and possibly those states in red, they could consider these same kind of tax increases on vapor products in 2022. Now, with no state legislatures actually passing tax increases in 2021, except Maryland through the veto override, the question comes, why didn't they? There's a couple of explanations. First, last year, state budget projections due to COVID-19 showed almost all states projecting a budget deficit. However, those deficits generally turned out not to be as large as expected, or they even turned into a budget surplus. Second, as a part of a stimulus bill known as the American Rescue Plan passed by Congress and signed by President Biden, collectively, all 50 states are either receiving or have received direct one-time stimulus fund payments totaling $195 billion. This one-time federal money left almost all states in a budget surplus position in 2021, so the need to enact higher cigarette and tobacco taxes, or any taxes for that matter, had been significantly reduced. But with the stimulus money being a one-time payment, states may now be looking for more revenue this year and could consider cigarette, tobacco, or e-cigarette and vapor tax increases in their 2022 state sessions. This slide shows the states that had legislation last year to restrict or ban the sale of flavored tobacco products. Most of these bills would have banned all flavored tobacco products, menthol cigarettes, mint and wintergreen smokeless, flavored pipe tobacco, flavored electronic cigarettes, flavored hookah, etc. However, none of these bills passed in 2021. But even so, it's evident that given the increasing number of states that are considering flavor bans, we'll likely see more flavor ban bills being considered this year during the state sessions in 2022. For our last topic that I'll cover, I want to look at local ordinances from a slightly different perspective. But first, to get a sense of how many states have had cities or counties consider local restrictions by cities, towns, or counties. This slide shows those states in red where local ordinances have been considered over the past 10 years. NATO has been monitoring and responding to local ordinances since 2012. And 2/3 to 3/4 of the states have had cities, towns, and counties consider and possibly enact local restrictions. Currently, the most active states for local ordinance activity are California, Colorado, Minnesota, Oregon, and Virginia. But even so, every other state in red has also had local activity over those past 10 years. Now, in 2018, the city of San Francisco adopted a full flavor ban ordinance, banning all flavored tobacco products. After that was enacted, an important study was released in May of 2021 by the Yale School of Public Health, and it looked at the impact of the San Francisco flavor ban ordinance on cigarette smoking rates by San Francisco high school students. In fact, the study was funded by the National Institute of Health and the U.S. Food and Drug Administration. In the study, high school smoking rates were compared for 8 school districts, with San Francisco being the only school district out of those 8 where a total flavored tobacco sales ban was enacted by that city. So they looked at 7 school districts in other parts of the country and then San Francisco. The study found that San Francisco high school student smoking rates increased from 4.7% in 2017, the year before the adoption of the ordinance, to 6.2% in 2019, 1 year after the ordinance was enacted. That is a 32% increase in high school student smoking rates in San Francisco after the adoption of a full flavor ban. Now, before the full flavor ban, the San Francisco high school student smoking rate had continued to decline, just like the 7 other school districts. But the study concluded that San Francisco youth either went back to smoking cigarettes or started smoking cigarettes once all flavored vapor products were banned. In the study's conclusion, the author issued a cautionary warning when she wrote, and I quote, "These findings suggest a need for caution. While neither smoking cigarettes nor vaping nicotine are safe per se, the bulk of current evidence indicates substantially greater harms from smoking. Even if it is well-intentioned, a law that increases youth smoking could pose a threat to public health." Now, NATO is utilizing this study and its findings in responding to new local flavor bans by cities or counties. We're informing these cities and counties of this study because of the potential health impact of greater smoking by high school students. In addition, two other recent studies of smoking rates in cities that enacted full flavor bans also found that underage youth and even young adults either went back to smoking cigarettes or started smoking cigarettes when all flavored tobacco product options were taken off of retail store shelves. This indeed does create a new public health issue of higher smoking rates, something no retailer wants to see, nor NATO. So we're working to educate local lawmakers of what could happen if they do attempt to ban all flavored tobacco products. And that concludes my presentation for today. I'd be glad to take any questions, and I'll switch back to Ben and or Antoine for the questions. Ben, back to
Thank
you.
you so much for your presentation. You certainly provided a lot of great information and insight into our industry. We have Antoine Marie who's going to join us for the last part of the Q&A here as well. And what we're going to do, Tom, we're going to open up the floor to some questions. Guys, if you're still in the comment box, post any questions that you would like to ask Tom on his presentation today. We'll ask those on your behalf. Tom, I did want to start with something. Synthetic nicotine, as you know, has garnered a significant amount of attention as an alternative to tobacco-derived nicotine, and you provided that in your presentation today. How likely will the FDA be granted the authority to regulate synthetic nicotine?
Ben, I think it's fairly likely for this reason. When FDA Director Mitch Zeller presented a webinar to NATO members on December 2nd, he brought up the fact that the FDA is very concerned about the use of synthetic nicotine in electronic cigarettes, and that they could either regulate it as a component or part of a tobacco product or through congressional action. And then we had the new nominee for the FDA commissioner's slot say that he will close this nicotine loophole with synthetic nicotine. On top of that, a bill has already been introduced in Congress. So those three individual events, Director Zeller's comments by the FDA commissioner nominee, and the bill in Congress, tends to support the fact that this will be expanded to allow the FDA to regulate synthetic nicotine directly. So it'll regulate both kinds of nicotine, tobacco-derived and synthetic nicotine.
Okay.
Tom, we had a two-part question here from one of the viewers. I'll bring it up on the screen so you can see it too. So synthetic nicotine standard I guess they want you to offer some insight into the standard that maybe the FDA is looking at synthetic nicotine and how their approach to regulating it.
The FDA doesn't have a standard for synthetic nicotine yet, but it is looking at whether it can distinguish, is a nicotine in a product tobacco-derived, or is it synthetic nicotine made in a laboratory or otherwise? If they are granted the authority to regulate synthetic nicotine directly by Congress, then the FDA will create standards. What is synthetic nicotine, how it will be regulated, etc. So it's a little early to say what standard will be used because the FDA hasn't developed that standard yet. Once it receives its authority from Congress, if that bill is passed and signed by the president, then it will develop that standard, Antoine. But it's a little early to tell at this point.
And the second part of that question was, should the FDA want to close that loophole? Do you have an estimate timeline for when that might happen?
It depends on two things. Will the FDA pursue regulation of synthetic nicotine as a component or part? According to FDA Director Zeller, it can do that right now on a case-by-case basis. So from a timeline standpoint, it can do it now. Otherwise, we have to wait to see if the bill in Congress passes and is signed by the president and then goes into effect. So we're not quite sure how long that might be to take to go through the congressional legislative process. So technically, the FDA says they can regulate it now, but they want broad, direct authority from Congress to do it as well. We're just not sure how long that direct authority from Congress will take to go through the legislative process.
Okay.
I think we had a follow-up there again from Leon. And Leon, thank you for providing these questions. Did you get that last one there, Antoine? The follow-up on nicotine?
So that last question was, as a follow-up, So what is the standard for the tobacco-derived nicotine? Could the FDA regulate that?
They already regulate tobacco-derived nicotine. Remember, the FDA law says any nicotine made or derived from tobacco is regulated by the FDA, and it looks at that isomer level. It's the S nicotine isomer level of 99%. That's the standard the FDA has set for tobacco-derived nicotine. So they already regulate that. And that's in cigarettes, in cigars, in pipe tobacco, and so forth. That's already being regulated at the S nicotine 99% level.
Okay.
So that's the standard by which they're doing that. If that's what they mean by standard, that's the standard the FDA has published, that they look at that. From a chemical basis, that's the standard which they determine, is it tobacco derived or is it synthetic nicotine?
Tom, let's just switch our attention real quick and focus on another part of your presentation, menthol cigarettes and the flavored cigars. Why would it take a couple of years for the FDA or for a new FDA regulation banning menthol cigarettes and flavored cigars to go into effect?
It takes that long because of those 9 steps I referred to. And some of the most lengthy steps in that 9-step process are: 1, asking the public for comments. The FDA usually gives 60 to 90 days for the public, that would include the tobacco industry, retailers, wholesalers, and manufacturers, to submit comments or feedback to the FDA about the proposed regulation, why it won't work, why there are problems with it, etc. Then the FDA has to go back and read every single one of those comments. And generally, when the FDA has made this kind of regulation, they receive tens of thousands of comments, and they're required by federal law to read every single one and then determine whether any amendments are going to be made. That just takes time. So those two things of themselves, the public comment period and the review of the comments, will probably take close to a year in and of themselves. Then they have to go back to the OMB after they make any amendments to get it finally approved, etc. So it just takes time. And then once it's finalized, there could be litigation, as there has been in the past on some of these regulations, like the graphic cigarette health warnings. They're under litigation. That can also extend the time frame before something like that new regulation will become effective. So a lot of different moving parts there, but it's just the process that takes time.
Yeah. Okay. And can you elaborate on how some manufacturers have contested marketing denial orders issued by the FDA on, say, electronic cigarettes and vapor products?
Yes, they've done it in 2 different ways. Some have gone to court directly and sued the FDA, claiming that the parts of the application that the FDA said were not there were actually there. It was the studies. And the circuit courts have found, yes, that's the case. So they've overturned the MDO. Now, when a court finds that the MDO, the marketing denial, is overturned, that doesn't mean the product goes on the market immediately. What it means is the application goes back to the FDA for further substantive review. So the FDA is back in their hands to review it. The other method is some manufacturers have filed an administrative review request directly with the agency, where they're asking the agency internally, take a second look at our application. All of the parts of the application were there. The FDA has said maybe something's missing. The company saying no, it was not missing. So the FDA internally can review the application a second time and determine whether it receives a marketing authorization order or if whether the MDO will stand, the marketing denial order will stand. So those are 2, an administrative review or a court case is brought. Those are the 2 methods that these manufacturers have brought in response to marketing denial orders.
On the
Okay.
topic on flavor bans,
Yes.
we're seeing more and more flavor bans come up each year, especially as you kind of bring this topic to the forefront in TPE. What does the future of the tobacco industry look like in terms of flavor? Should manufacturers be continuing to try to push those kind of products, or should they be scaling back and just focusing on tobacco flavored items?
I think it's really based on consumer demand. Consumers like flavors, whether it be flavored water, flavored alcoholic beverages, flavored tobacco products. So if there's a demand for flavors, I think manufacturers will continue to supply that demand. If you note, though, the FDA, in reviewing the PMTAs on electronic cigarettes, have not approved a single flavored electronic cigarette yet. And they've denied almost 7 million electronic cigarette products, most of which were flavored. So you can see where the FDA is going, is to remove most, if not all, flavors. Now, the one flavor it has withheld judgment on in these PMTAs is menthol flavored nicotine liquids. It hasn't issued a denial order yet on some of those major electronic cigarettes that have menthol cartridges or menthol e-liquids for use in vaping products, because the FDA has stated that they still want consumers who smoke to have an option, not just of tobacco flavored, but possibly menthol flavored electronic cigarettes, so they can switch from menthol cigarettes to menthol vaping. Because the FDA has indicated that vaping is less harmful than a combustible cigarette. Even though no one should use those according to the FDA, it is less harmful. So they want to leave that option potentially open, but we haven't seen MDOs on specific menthol products yet. We're waiting for those as a part of this ongoing review process.
And we've also seen, I think a couple, if it wasn't last year, the year before that, the FDA indicated that as they were kind of going to be reviewing the PMTAs, that they were going to put some of the bigger manufacturers first in their review, and then they seem to have backtracked on that a little bit, and we've gotten a lot of marketing denial orders on some of the smaller manufacturers, and now the bigger manufacturers have not received anything. What do we need to know about that topic or that situation?
The only major manufacturer which has received a marketing authorization order is RJ Reynolds for its Vuse Solo product, but its Vuse Alto product still remains under review. And you're right, we have not seen MDOs or marketing authorization orders for Juul products, for Enjoy products, for the RJR Vuse Alto products. It's a matter of time. The FDA is using its enforcement discretion to extend the time to review these and make scientific decisions. They just didn't have enough time by September 9th of 2021 to finish all of those reviews. But remember, there was a court order that the FDA finalize its reviews by September of 2021. When that didn't happen, the health groups that initially sued the FDA to speed up this review process have now gone back to court. They've asked the court to require the FDA to report back to the court on its status of its pending applications. Where are those other applications that have not been finalized in the review process? We haven't seen anything yet filed with the court, but they have asked the court to require the FDA to submit those updates, so to speak, on reviews. So, Antoine, it's just a matter of waiting patiently until the FDA finishes its reviews. It wants to do these properly and file their scientific guidelines to get these done. It just takes a lot of time. Some of these applications are millions of pages long in terms of clinical studies, reports, and data, and it just takes time to get through all of those. And I think that's why some of these applications are taking longer than the September 2021 deadline.
Yeah, I think that's a fair point. Tom, I did have a question. So with, and grateful for the presentation that you gave us today. What do you think the future looks like for new products and brands on the market, 2022 and beyond?
I think it looks good. I think the FDA, is not allowed under the law to ban an entire segment of product. They can't ban all cigarettes. They can't ban all smokeless, et cetera. They can't ban all tobacco products, in one segment. That's very specifically stated in the FDA law. So they have to authorize products which are less harmful, because they have what is called a continuum of harm. On the one end is combustible tobacco products. Those are the most harmful. On the other end of the spectrum is your Nicorette and gums to quit smoking, and everything else in between. And they want to still look at approving those products because some consumers need nicotine. So manufacturers understand that, and they're coming out with the modern oral nicotine products, much less harmful, and usable for those people who still need nicotine. So the FDA it's incumbent upon them to look at those products. And if they do meet the standard of being appropriate for the public health as Congress set down, then they need to approve those. And we've seen some of those, the Vuse Alto product, et cetera. And they have given even modified risk tobacco product designations for some of the Swedish Match snus products because they're less harmful. So they are recognizing that there is a place for less harmful tobacco products in the marketplace for consumers who need nicotine. And they have to approve those. So we're looking forward to the manufacturers still developing other tobacco products as we move forward, generally on the less harmful end of the spectrum.
Perfect. And Tom, just to finish up and wanted to ask, how can people get involved with NATO? What can they do on a local or federal level? How can they get involved with your organization?
Well, if they're already a NATO member, and we have some 65,000 stores nationwide that are, from tobacco stores to convenience stores, grocery stores, and liquor stores, you'll receive alerts from our NATO staff if there's a local, state, or federal issue that we need you to respond to. If you're not a NATO member, certainly go to the NATO website. It's natocentral.org, and there's a tab there, Join NATO. It's not very expensive at all to join for retail membership, and you receive so much information on FDA regulations, state legislation, and local issues. We're there to help you oppose these to remain in business. And that's our key goal, is to make sure that retailers are able to sell legal tobacco products. And that's what we've been doing for 20 years. NATO just celebrated its 20th anniversary in 2021. We're coming up on our 21st anniversary. So we're here to help retailers. So if they want to join, we'd certainly encourage them to do so.
We want to take one more question from
Sure.
our viewers today. This is from Robbie. He says, if the FDA has taken the position that synthetic nicotine does fall under their jurisdiction and no law or judge tells them it doesn't, then who's stopping them?
Well, remember, the FDA is claiming that it has jurisdiction or authority to regulate synthetic nicotine on a case-by-case basis if it's considered a component or part of a tobacco product. So even if a court doesn't rule that the FDA has no authority, there is that reference to FDA authority under the component and part of the FDA law. So it would probably require action by Congress to clarify that, because there is some ambiguity there, but the FDA says it will still regulate synthetic nicotine as a component or part, but it's on a case-by-case basis. I think as more and more manufacturers potentially switch to synthetic nicotine, there'll be more pressure on Congress to authorize the FDA directly to regulate synthetic nicotine. So it's really up to Congress, I think, to put a final answer to the question, when will it regulate all synthetic nicotine? That's for up to Congress to do.
Awesome.
Right.
Thank you.
Well, I think that wraps up our comments and questions for now. Tom, we wanted to say thank you so much again for joining us this year for our TPE Ignite online educational series. Antoine, did you have any other questions or comments?
No, I don't for today.
Well, guys, thank you again for joining us. We have another session tomorrow at 12 p.m. This is going to be best practices in tobacco. If you haven't done so already, please make sure that you register for the TPE 2022 in-person trade show, which is going to be held on January the 26th through the 28th in Las Vegas at the Las Vegas Convention Center. Guys, this is a sellout show this year. It's one you would not want to miss. Visit tobaccoplusexpo.com and click on the register to attend button and sign up today. We'll see you tomorrow at 1 o'clock, and we'll be doing these sessions for the rest of this week. Thank you so much for joining us. Have a great day. Bye-bye.